and this is Theory of Limits, Part 4. The theory of limits in Islamic legislation is based on the notion of a flexible system of contingent law that replaces legislation containing rigid regulations and certain penalties that allow no mitigation and are thought to be once and for all fixed. Taken up again, an analogy with the measurement of blood sugar in the blood. We propose a system that allow much tolerance in what is perceived to be normal. That is, we tolerate blood sugar levels within the range of 70 to 120 mg, because we believe that if we insist on a strict limit of just 70 mg as the only acceptable level of blood sugar, we would seriously risk the health of millions of people. Doctors all over the world know that 70 mgs is just the lower limit, and that blood sugar levels of up to 120 mgs, the upper limit, can be tolerated. The legal verses of the book provide us with the legislative framework within which we may adopt the new law required by social change. A framework of legislation does not contain, as many believe, certain penalties which turn into sources of law, but just their outpost, or, to use a football term, their sidelines, for example. In some legal cases, one may not even come near such a sidelines. In others, it is permissible to touch the line without fully stepping over it. Analogous to a football match, Islamic law allows movement over the entire football field. Sidelines only indicate the limits within which the game can be played, while still allowing millions of different ways to play the game and of applying different tactics and strategies. Islamic law, after Muhammad's messengerhood, requires legislation within the limits of Allah, allowing an unlimited number of different legislation according to the need of society. That is why Muhammad's messengerhood is called Mother of the Book, al-Kitab, and not just book, as Moses and Jesus' messengerhoods were called, because it allows millions of books of legislation to be derived from it. And as the mother of books abrogated the previous books of Moses and Jesus, so will future legislations books subsequently abrogate each other. Not, of course, within weeks or months, as some of our critics have insinuated. Now, limits of legislation. 5. Lower limits are provided in A, the verses of marriage, and marry not women whom your fathers married, except what is past. It was shameful and hideous and abominable custom indeed. Surah Nisa, verse 22. Also, prohibited to you for marriage are your mother's daughters, sisters, father's sisters, mother's sisters, brothers' daughters, sisters' daughters, foster mothers who breastfed you, foster sisters, your wife's mothers, your stepdaughters under your guardianship, born of your wives to whom you have gone in no prohibition if you have not gone in, those who have been wives of your sons proceeding from your loins, and two sisters in wedlock at once at the same time, except for what is past, for God is oft forgiving, most merciful. Surah Nisa, verse 23. In these two verses of Surah An-Nisa, Allah has issued a rule that provides a lower limit, prohibiting certain marriage types. Nobody is permitted to transgress this lower limit. Under no circumstances is an ijtihad acceptable that, for whatever cultural or political demands, aims at allowing a Muslim believer to marry his mother, daughter, maternal or paternal aunt, and like that. However, since the lower limits stand alone in the text, one may add further restrictions. For example, if medical tests indicate that children from couples who in some cultures permit first cousin marriages, are showing higher risk of developing genetic disorders, the legislator is required to respond and to extend the list of prohibited marriage partners to the children of maternal or paternal aunts. Note that this prohibition can never be an absolute taboo, because this is God's prerogative. Such an extension would not violate Allah's limit, because in stipulating possible marital arrangements, he did not provide an upper limit. The only condition is that clear scientific proof must be provided before any new legislation can be introduced. This means that a call for ijtihad must be based on scientific evidence and not an analogy. Analogies compare newly arising legal problems with previous legal cases or with a consensus of jurists who lived in the past, such as the Salaf forefathers. Such analogical reasoning is, by definition, retrospective and regressive. It prevents Islamic legislation from being truly Hanific, that is, changeable, progressive, and adaptive to new scientific discoveries. B. The food taboos. Verse 3 of Surah Al-Ma'idah lists carrion, blood, and swine flesh as prohibited food, as well as food that has been dedicated unto any other than Allah. This constitutes the lower limit for those who want to legislate what is illegal to eat. A different category is meat, of the strangled and the dead through beating and the dead through falling from a height, and which had been killed by the goring of horns and the devoured of a wild beast. Food from this kind of meat cannot be regarded as an absolute taboo, because if one manages to slaughter it correctly by an invocation of God's name, it becomes halal food and hence edible, as stated in Surah An'am verse 145 and An'am 119. These two verses of Surah Al-An'am state that under the duress, one is allowed to eat food that is normally forbidden. A transgression of Allah's lower limit is hence permitted, provided that we did not invent the reason that forced us to eat forbidden food. Such an exemption from the normal rule, however, does not exist with regard to marital arrangement. Under no circumstances is one permitted to cross the lower limit, not even in exceptional circumstances. Even if marriage outside one's own family has become virtually impossible because of a dramatic shortage of unmarried women or men, it will still be illegal to marry those close relatives. C. The regulations of concerning debt. In verses 282 to 283 of Baqarah, Allah stipulated the lowest limit for what can be accepted as a valid contract. Since no upper limits has been set, further regulations might be added to that reflect the changing nature of financial contracts and the ever-evolving rules of society's commercial markets. Note that the minimal requirement of one man or two women only refers to an oral contract, so that if one of them errs, the other can remind her. If two women must appear in person to witness the signing or sealing of a contract, it is because the contract is only expressed orally and not in writing. However, if such contract is produced in written form, the testimony of two females is no longer necessary. In this case, the minimum of one man or one woman is all that is required. We reject all sexist interpretations that explain double female testimony as proof of woman's inferiority, and that's an indication of their incompetence in commercial affairs. D. Women's dresses. And say to the believing women that they should lower their gaze and guard their lower private parts, furujuhinna, that they should not display their hidden beauty, zinatuhunna, except what visibly of her beauty appear thereof, that they should draw their veils over their upper private parts, jiyubuhunna, and not display their hidden beauty, zinatuhunna, except to their husbands, their fathers, their husband's father, their sons, their husband's sons, their brothers, or their brother's sons, or their sister's sons, or what follows next in line, nisa'ahunna, of the next level of male and female, or the temporary partner whom their right hand possess, or male persons free of physical needs, or small children who have no sense of the shame of sex, and that they should not strike their feet in order to draw attention to their hidden beauty, zinatuhunna. O you believers, turn you all together towards God, that you may attain bliss. Surah An-Nur, verse 31. In stipulating the rules of how women are required to cover their body, the book merely provides us with a lower limit. The reason why only a lower limit is stated and what exactly this implies will be explained in later detail. Suffice it was to say that here that Surah 4 verse 31 allows, under certain circumstances, to transgress the lower limits of Surah 24 verse 31, which is similar to the case of contingent food taboos in Surah An'am. It is, however, different, as we mentioned, from the absolute rule that one must not ignore the limits of marital partners as provided in Surah Baqarah. Thank you for following Theory of Limits Part 4. Part 5 is next. Let us hear your thoughts.